Breaking news out of Cook County, Chicago, Illinois. A decision by a lower state court judge there seems to have gotten wrong when it comes to the Second Amendment's right to keep and bear arms and the power of governments to tax it. Stay tuned. I'll break it down for you when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the Bill of Rights. Okay, folks, we have breaking news out of Chicago, Illinois. Specifically, a state trial judge in Cook County has decided, effectively, that the Second Amendment has not been violated by a Cook County tax specifically targeting firearms and ammunition purchases. Now, this appears to be a clearly wrong decision. The name of the case is Donald Vandermyde versus Cook County. In this case specifically, it is a lawsuit challenging a tax that specifically targets firearms and ammunition, which, as you know, is unconstitutional. We'll get to that in a second. Now, what's happened here is this trial court judge, as I read this and as I understand it by looking at kind of the prior decisions in this case going all the way up to the Illinois Supreme Court, is it looks like this is a little bit of a dodge. And what I mean by this is that this trial court judge, which I'll put a link to the decision down below, is basically trying to say, oh, I'm bound by some other state court rulings on this issue that already decided that the right to keep and bear arms is not implicated by this particular tax on ammunition and firearms. But I got to tell you, it looks like a little bit of a sketchy decision here in terms of whether or not that analysis is correct. Bear in mind that the decisions that they're relying upon from the more superior courts in the state of Illinois, those decisions, as I recall, were decided before a case you may have heard of. That was before Harper versus Bruin was decided in June of 2022. So one wonders how a lower court judge could be relying upon Second Amendment-related decisions, even based in Illinois state law, that arose before Harper versus Bruin was decided. Seems like maybe you need to analyze that a little bit more robustly than a page-and-a-half decision, which is what happened here. So let me try to help out the Illinois state court system on this particular point. Let us just step back for a second and start with basic principles. In 1983, the United States Supreme Court decided a case called Minneapolis Star Tribune. In that case, it said that a specific tax on ink, violated the First Amendment's right to free speech and to free press. The reason why this is important is because they said that you cannot target a constitutional right with taxation. It is unconstitutional under the First Amendment and the rest of the Bill of Rights. This is also consistent with an earlier Supreme Court decision called Harper versus the State Board of Education, a decision from the 1960s where the Supreme Court struck down a $1.50 poll tax imposed by the state of Virginia. So when you take the Harper case, which says that you cannot tax people for the right to vote, and you take the Minneapolis Star Tribune case from 1983, both Supreme Court decisions, both say that you cannot tax constitutional rights. It bears mentioning that the Illinois State Supreme Court is well aware of the unconstitutionality of taxing constitutional rights. In a very famous case by the Illinois Supreme Court, known as Boynton versus Cusper, this is a 1986 case. They specifically relied on the Minneapolis Star Tribune Supreme Court case that said you cannot tax constitutional rights. Now, the Boynton versus Cusper case by the Illinois State Supreme Court relied on the Minneapolis Star Tribune decision by the United States Supreme Court to do what? It struck down a specific marriage tax. That's right, a marriage tax that the state of Illinois had enacted and charged people to get married. But Boynton versus Cusper said this is an unconstitutional tax. You cannot tax marriage. And it cited Minneapolis Star Tribune, the Supreme Court case. But for some reason here, in today's decision, dealing with, in the case of Vandermyde versus Cook County, this court dodged all of this. Now, what this court should have done, in my view, is it should have conducted an independent analysis of the Second Amendment and figure out whether or not taxes are implicated in the right to keep and bear arms. Now, obviously, we know that the right of the people to keep and bear arms has necessarily implicated within that plain text the right to acquire arms. Because we're not born with arms, we have to at some point acquire the arms to exercise our right of the people to keep and bear arms. So as a consequence, if you have a targeted tax on our right to keep and bear arms, to acquire those arms, that clearly, in my view, violates the Second Amendment, no different than the Minneapolis Star case indicated that a targeted tax on the First Amendment right to free speech and the right to free press violates the First Amendment. So too, in the Harper versus Board of Elections case out of Virginia in the 1960s, a poll tax on voting violates the right to vote. So it seems to me that what this judge should have done in Vandermyde is simply analyze the plain text of the Second Amendment, conclude that the right to keep and bear arms includes the right to acquire it, and if you tax an individual who's trying to acquire firearms and or ammunition, of course ammunition is necessary to use the firearm for the purpose of being a firearm, well, obviously that should violate the Second Amendment, especially in light of that Supreme Court precedent. But this judge simply refused to do so and has punted by saying that I'm bound by decisions by superior courts here in the state of Illinois, but I'm a little skeptical of that rationale given the fact that those prior court rulings that this judge in Cook County relied upon were all decided prior to June of 2022, which is significant because that was the month in which Harper versus Bruin was decided. So how can those prior decisions have accounted for the methodology and rationale of Harper versus Bruin if they were decided before the case even existed and was decided? Inquiring minds want to know. Okay, folks, I hope you learned a little bit something here today about the Second Amendment and taxation and some Supreme Court precedent as applied to this pending case called Vandermyde in the Illinois state court system. We'll keep an eye on this and report as developments break. And if you haven't subscribed to the Four Boxes Diner, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.